Ladies and gentlemen, we're about to start. Our last and final plenary is on the extension of the doctrine of vicarious liability. And our two speakers, Ms. Kirsten Eiser and Nivaani Moodley, both from Wentzel. Just going to give you a quick introduction on their bio. Ms. Kirsten Eiser specializes in employment law. Her experience includes drafting and advising on employment contracts and employment-related commercial agreements, developing employment policies and procedures, and conducting the employment-related aspects of due diligence and investigation. Her expertise extend to advising on restraints of trade agreements and labor law-related litigation, arbitrations, alternative dispute resolution. She also has experience in matters related to data protection. Ms. Nivaani Moodley specializes in labor litigation and corporate employment law. She has experience in dealing with retrenchment, transfers of aspects of business, ladies and gentlemen, exercising COVID regulations, sanitizing, social distancing. Our next speaker. Thank you.
Thank you very much, Lorata. So in 2019, there were a number of very interesting judgments that were handed down in respect of vicarious liability in the employment relationship. So what we will be looking at today is the doctrine on vicarious liability and specifically those interesting cases that I mentioned. So just to give a roadmap of where we're going today, we'll first look at the origins of vicarious liability, the definitions, as well as the tests. We'll then discuss the three cases I mentioned. Those cases are Stallion Security versus Van Staden, which is a Supreme Court of Appeal judgment. We will then look at Anguan versus Minister of Police. The main question of when can an employer be held vicariously liable for the conduct of an employee. So when looking at the origin of the doctrine of vicarious liability, it turns out we're not actually quite sure where it comes from, but we know that it comes from Roman Dutch law and has found application in South Africa due to us following English law. It is a doctrine that is followed in most jurisdictions, America, the UK, and in fact, when our constitutional court has looked to develop and interpret the doctrine, it has had regard to these foreign jurisdictions on when, how, and why to expand it. Now, vicarious liability is a legal concept that and also underpinning vicarious liability is the concept of liability without fault, which I will discuss a little bit further on. Now, the general principle in a delict is that a person will only be held responsible for damages suffered by another in instances where that person has committed a wrong. Now, the exception to this rule is found in the employer-employee relationships. And our courts have long held it's a wrongful act. Whilst he is acting within the course and scope of his employment, the employer is liable for damages resulting from that act. Now, to understand vicarious liability, it's important to understand strict liability. In this quote here from Nietling, Potgieter, and Visser, they state that vicarious liability may in general terms be described as the strict liability of one person for the delict of another. The former is thus indirectly or vicariously liable for the damage caused by the latter. So another theory underpinning delict is the fault theory. And what this theory says is that in order to hold a wrongdoer to account, they need to have acted with fault. And that is either with intent, so they meant to no-fault liability, which underpins vicarious liability. It's a situation where someone is held liable despite the fact that they are not at fault. They had no intention and they didn't act with any negligence. And strict liability, again in the employment context, is well established because of the application of vicarious liability. Now, any person wishing to claim from an employer based on vicarious liability has to prove the following three requirements. They must have committed a delict, and finally, the act, the delict that was perpetrated by the employee must have taken place within the course and scope of employment. So where an employee commits a delict while going about their business as employer, it's quite easy to and that was wrong. And finally, he was acting in the course and scope of employment. He was delivering documents. The difficulty, however, with vicarious liability arises when we look at a situation where the employee commits an act intentionally and completely for his or her own purposes. And these are kind of known as your deviation situations. And these deviation situations create real uncertainty in the law on the test for vicarious liability, because you cannot rely on that common law test. So this was considered by the Constitutional Court in the Minister of Police versus Robbie, and they created a test to be applied in cases that deviated from the standard matters. And this test provides that an employer can still be held liable even if the employee abandoned his or her duties and acted negligently or intentionally on his or her own, provided that there is a sufficiently close connection between the actions of the employee and the business of the employer. And how they formulated this test is that it has two sections. The first is a subjective test, and it asks whether the employer or the employee performed the act in his own or his employer's. Objective test says if he acted in his own interests, whether there was a sufficiently close link between that conduct and his employment. So to see these tests in action, I'm going to hand you over to Nivaani, who's going to discuss the first case.
Thanks, Kirsten. So the first case that we will be discussing is Stallion Security versus Van Staden. As background, Mr. Khumalo was employed as a security guard in Stallion in 2013. He was then subsequently in 2013 promoted to site manager. So Bidvest security at its premises. This was at 3 of its premises, one of which being at its head offices, in which Mr. Van Staden worked as the finance manager. So Mr. Khumalo, in respect of his duties, he had intricate knowledge of the premises. He knew about the whereabouts of the employees, their comings and goings. He also was in possession of a bypass key or an override key, and the purpose of his visits undetected. Bidvest used a biometric system where you would know that personal information is stored, and by use of the override key, Mr. Khumalo would be able to make visits to the premises of Bidvest, which were unrecorded. So using his knowledge of what he knew about the premises and what he knew about the employees, Mr. Khumalo had attended Bidvest's premises one afternoon. This was prior to, or just taking a step back, a month before the incident, which was during October. He started looking unkempt, and Bidvest had actually asked Stallion to remove him as an employee and to replace him with somebody else. So one afternoon in October, Mr. Khumalo attended at Bidvest's premises, and he knew that Mr. van Staden would be working late or after 5 in the afternoon. He also knew that Bidvest had a petty cash box, and he used his bypass key to locate Mr. transfer 35,000 Rand of Mr. van Staden's personal money to Mr. Khumalo. This was because he was actually looking for the petty cash box, or the money in the petty cash box, but Mr. van Staden did not have access to that key. This 35,000 Rand was not sufficient for Mr. Khumalo's purposes that he required it for. And he then asked Mr. van Staden to escort him out of the premises using Mr. van Staden's biometric details and shopping center. The intention of this trip was to actually try and secure the rest of the money. While they were on the trip, he feared that Mr. van Staden, because he knew him and had a personal relationship with him, would report him to the police. And so he shot and he killed Mr. van Staden. And she founded her claim on vicarious liability. So the question that was before the High Court was whether, on the facts of this matter, there was a sufficiently close link that existed between the wrongful or unlawful conduct of Mr. Khumalo on the one hand and the business or the enterprise of Stallion on the other. So the High Court found that Mr. Khumalo murdered Mr. van Staden purely for his offenses. However, there was a sufficiently close link to the unlawful act and the business of the employer to hold Stallion vicariously liable. And the question that they asked was whether the employer had created the risk of harm that materialized, and that must be determined objectively. So the Supreme Court of Appeal found that Stallion had afforded Mr. Khumalo with more than just a mere opportunity to commit the wrongs in question. He had intricate knowledge of the premises. He knew about the comings and goings of its employees. He was given the bypass or override key. He was required to make unannounced visits from time to time. And ultimately, Mr. Khumalo was in a special position to allow him to abuse his power. And Ms. van Staden was awarded 1.6 million Rand in damages. Kristen, over to you for the next case.
Thanks, Nirvani. So in the next case of Anguan versus Minister of Police, it's a High Court judgment. What happened here was the plaintiff was returning home. He flew into PE George Airport, and he was driving home when another vehicle started flashing lights at him and trying to run him off the road, is what he thought. He was quite nervous, so he drove into a municipal area, which was well lit, and pulled over. The other car pulled over too, and it turned out that the driver of the other vehicle was a good friend of his. And they were friends. and not realizing they were actually kind of in front of someone's home. And a man came out of the house and started using crude language to get them to move. As Mr. Anguan was trying to diffuse the situation, the gentleman started hitting him with a metal stave on his head and across his back. While this commotion was going on, a police vehicle drove past and tried to stop the altercation, and it was then that Mr. Anguan realized that his attacker was actually a police officer. And now Mr. Anguan wanted to bring a case against the Minister of Police for vicarious liability due to the conduct of the police officer. And the question that the High Court had to answer was the wrongdoer acting within the course and scope of his employment? In other words, was the wrongdoer engaged in the affairs of his employer when the wrong occurred? And the High Court, in making its determination, considered the Stallion case that Nirvani just discussed, and found that for very obvious reasons, the Stallion case was very different. In the Stallion case, Khumalo was specifically tasked to protect the customer and its employees. He had gained access to the premises after hours because he was given a key to the premises, and he had that key because of his employment. In this case, however, there was no evidence that the policeman was on duty. In fact, we understand that he was wearing only the pants of his police uniform. There was nothing else to identify him as a police officer. He never identified himself as a police officer, and he never purported to exercise any official power. So the High Court, in applying the test, said, subjectively speaking, the policeman in the matter was not acting as a police officer. He was acting for his own purposes. And objectively speaking, his conduct was not sufficiently connected to his employment to render the state liable. And so accordingly, the state could not be held vicariously liable for his conduct. Okay, Nirvani, just the last case.
So the last case she had many duties, including assessing offenders to determine the relevant therapeutic plans that were appropriate for the offenders. This assessment formed part of an offender's sentence plan. An integral part of the second defendant's duties. So although the plaintiff wasn't directly reporting to the second defendant, she did consult with him often regarding issues pertaining to the with other employees employed by the center as well, in a vehicle that was used by the center. On the morning of 9 January, that she was responsible for, in respect of a stockroom that she was responsible for. After helping him with an email, he requested that he speak to her about something else. So assuming that he was going to speak to her which was provided to him by one of the offenders regarding a restorative justice program, and he asked her to comment on that pamphlet. After she had provided her comments, he asked about her young daughter and said that he had a dream about her as a man dreams about a woman. She became very uncomfortable and stood up to leave. Before she could leave, the second defendant sexually harassed her and kissed her against her will. She managed to escape to her office, which was just a mere 20 paces from the second defendant's offices. And this incident occurred on a Friday, and she reported the incident to the head of the center on the Monday. The second defendant was called to task and was disciplined. He was found guilty in the disciplinary hearing and also in criminal proceedings against him. So the question that was before the High Court was whether the second defendant's conduct was sufficiently closely linked to the business of the employer to make the employer vicariously liable for the conduct of the second defendant. Now, this matter, well, this case is distinguishable from the previous cases that we've discussed and the Stallion case in that in those cases, the purpose of the business was to provide safety and security, whereas in this case, it was about a correctional service. Speaks to the subjective test that we spoke about earlier, and it also dealt or used the test in Stallion and found that it was applicable in order to determine whether the center was vicariously liable for the conduct of the second defendant. The court also drew on another case called Eiser, created a vicarious liability for the employer. In this matter, the employer argued that agreed with this and stated that even though the second defendant wasn't directly in charge or directly responsible for the plaintiff, he was in fact her de facto supervisor in that he did supervise her. So the court held that as a result of this de facto relationship, the dynamic between the plaintiff and the second defendant was unequal, and that the pamphlet that they were discussing immediately prior to the incident was within the course and scope of employment. If we look at the subjective and the objective tests, subjectively speaking, immediately before the incident, the second defendant was discharging his duties in furtherance of the center's business, and the de facto relationship between the second defendant and the plaintiff was not only created but further facilitated by the center. Objectively speaking, his conduct was sufficiently closely linked to the business of the employer, and so the employer was liable for the damages. So based on these two findings, the court found that the first defendant was indeed vicariously responsible for the actions of the second defendant. If we go back to our question that we asked in the beginning, when can an employer be responsible for or be vicariously responsible for the actions committed by an employee? There are 3 tests that need to be met, the first of which is whether the act has taken place within the course and scope of employment. Secondly, whether the employee performed the act in his or her employer's interests. And thirdly, whether there is a sufficiently close link between the conduct and the business of the employer. So that concludes our presentation. Is there any questions that anyone would like to ask?
Oh, I think, thank you for taking over that part. I think that's a
Sorry.
pass over the
Oh,
mic.
girl.
Thank you so much, ladies, for the presentation. My question relates to your year-end functions. You know, we all get a bit excited, and then people have to drive home. In the event that an accident does occur, would that be a possible claim of vicarious liability? Or, yeah, I just...
Okay, well, that's quite an interesting question. It's quite an interesting question. I suppose you're saying the employer created an environment for their employees to drive home drunk. Subjectively, I'd say they are acting in their own interests on driving home drunk. Whether it's sufficiently connected, I think would depend on the specific facts. That's a very lawyer response. But I think you would need to look at, did they, provide for responsible drinking? Did they say Ubers would be made available? A party isn't really, related to the employer, So I think you would have to look at the facts, but there's potential for it depending on the circumstances. Don't know what you think, Nivaani.
Yeah, I agree. I also think that it would depend on the facts. But I suppose it would also have regard to whether there are any policies in place that the employer has prohibiting such activities. Ultimately, I suppose the employee would have to be responsible for his own well-being as well. But I think that it would largely depend on the facts of the matter, but there is possibly scope that the employer could be held liable depending on their specific actions.
Okay. We have time for a second question. Oh, you guys are awesome. Please.
It's interesting for me just looking at the Stallion and the correctional service case that, you ladies would have read the judgments. Does the court in those two cases ignore the illegality or the criminality carried out by the employees of the two employers? Do they comment on whether the action, the fact that the action is illegal or it's criminality?
So
doesn't have impact on the claim.
So one of the core elements in vicarious liability is that the employee must have committed a wrongful act. So it's kind of taken for granted that that's already been kind of proven. I know, as we discussed in the last case, he'd actually already been found criminally liable of sexual harassment. And it was the facts of, in the Anguan case, it was accepted that the police officer had committed an assault. And I believe that is the same for Mr. Kumalo, who shot and
That he subsequently escaped, and he is no longer alive, apparently. Yeah.
Okay, I think, do you need a mic?
Let me also try to project it.
Okay, we're gonna need the mic for the people that are streaming in virtually. Thank you.
Thank you. My question relates to with the COVID-19 and the scope of the definition of workplace, since everyone is working from home. Vicarious liability.
Yes, absolutely. If you were acting in the course and scope of your employment, even from home, and you committed a delict in the course and scope of your employment, it would satisfy vicarious liability.
Yes, I agree.
Any other questions on the floor? I think maybe my question may seem a bit primitive for someone that's supposed to be well informed of the law, but maybe someone at home, after your presentation on the 01 case, in light of the police having this stance, or the community believing that they're the protectors of society, how would it work in instances where you're in a remote place like the villages, where really a police officer is known as the protector. They don't have on or off duty. And there is an obvious risk that if you're in a remote area, then there is a chance of abuse of power. How does vicarious liability or a person at home utilize that to protect themselves, or if they have been a victim of such? In light of Wang, I mean, he was only wearing pants and couldn't be identified, but in a remote place, everyone knows that Mr. X or Miss X is a police officer and is the only one there.
Yes, so it wasn't in that particular case in Anguan, because it was that people didn't know that he was a police officer, but there are actually a number of cases that deal specifically with trying to hold the Minister of Police vicariously liable, and they were held vicariously liable. And I mentioned the Minister of Police versus Robbie case, and that is one of such cases. Here, a woman was stranded and took a lift with police officers thinking that this was safe, and they kidnapped her and raped her. And she brought a claim for vicarious liability. And here they said, they looked specifically at the fact that police have a positive duty of protection, and that members of the community would see a police officer, a police car, men in uniform, and by virtue of their duty that they owe, which is a legislative duty, it was reason, she would get into the car and expect that they would take her home. And even in that case, it's actually unlawful for the police officers to give a lift like that. But the court said, notwithstanding that they weren't acting within, what's lawful, it was sufficiently closely linked. So in those situations where you do have people within the community who are known as police officers, and they use that trust to commit intentional wrongdoing for their own purposes, the courts have held their employer, the Minister of Police, vicariously liable.
Oh, I think, how is our time? Can we say? Okay, because there is one question on the floor. I think the gentleman will approach you guys after. Thank you very much for your time, and thank you for participating meaningfully, ladies and gentlemen. As a small token of the committee's appreciation, I would like and that is a wrap for today, ladies and gentlemen. See you tomorrow morning.